Stephen Breitfelder from the Cincinnati Fire Department and Chief Preston Moore from the Whitehall Division of Fire. Both of them will discuss their arbitrations. Then we also have Chief Mark McCann from the Central Ohio Joint Fire District and Chief Dan Stitzel from the City of Franklin Division of Fire. And they will talk about their incidents that were handled internally. Chief Stitzel at the time was with the City of Riverside. And also with us again is Kelly Babcock from Clemens and Nelson, and Kevin Shannon, the Law Director from the City of Groveport. Again, I want to recognize the Deputy Chief Rick Vober for his assistance, Sherry in the OFCA office, and along with our Executive Director, Michelle Fitzgibbons. Please hold your questions until the chiefs have finished. Let's get started. I'm going to have Chief Breitfelder from Cincinnati start with the discussion of their arbitration. Chief.
Well, good afternoon, everyone. And I believe I'm showing up as Jack Rupp. I am not Jack Rupp. I am Steve Breitfelder with the Cincinnati Fire Department, Assistant Fire Chief. That was due to the trouble I was having getting logged on. But I'm Assistant Chief with Cincinnati Fire. I'm currently oversee our operations in the EMS division. At the time of the members were tested, I was in charge of the Human Resource Division. So I oversaw the random testing process for the Cincinnati Fire Department. So I'll give you a little background on our testing process and then kind of go how it lead into how it went into arbitration, and then give you a quick summary of what I feel are the key factors that in the arbitrator's decision-making process and the ruling on it. So according to our labor management agreement, I'm going to probably throw the terms labor management agreement and collective bargaining agreement out, but they both are be used in the same manner. We do random testing once a month. So we send out a notification. It's no notice, randomly select people, and they go down to a testing facility that we have designated, we've agreed with the union to use, that is federally certified for the testing process. And if they're on duty, they'll go down there, report, get tested. And these two individuals, they were both tested at different times during different months. But when it came to the mediation and the arbitration, both the cases were lumped together because they were very similar. So the members reported down for a drug testing. Their drug testing was done through a urine sample. And then we got notification anywhere. I think one of them was 3 days, maybe it was 5 days, and the other one was 7 days. We got notification that they tested positive for marijuana metabolites. So what we did then is our internal investigation section will go down when they're on duty. We serve them with a letter that is basically a mandatory PEEP, Public Employee Assistance Program referral. And then they are sent off on leave of their choice. So they can either take their vacation holiday or sick with pay leave. They have to make contact with PEEP, get in, do a mandatory referral. And then they have to go through whatever drug treatment program is recommended by the PEEP counselor. Both members did that. They actually went to the same place. It's right across the river in Kentucky. I believe it was around 5 to 6 weeks long for them to get that done, just due to the scheduling of the dates for the program. They both had to pay $350 out of pocket. And then once they had a negative test, we allowed them to come back to work. And then it goes through, once that was all done, it started going, they immediately grieved that. And their grievance was based on the fact that they had a card for medical marijuana. And they presented that card, but they still were found that they were in violation of the union contract because they were using an illegal substance, even regardless of the state law that allows it. So it went to mediation. We found no agreement, and then went to arbitration. So that's where I'll kind of pick up with the arbitration process and things that we looked at in the ruling of the arbitrator. I will tell you first off, ours, when it went to arbitration, this was considered a contract interpretation for the arbitrator to decide on. And the union had to prove beyond doubt that we violated the union contract. One of the things, obviously, we're all aware there's a difference between the state allows medical marijuana if you have a card. However, the federal government does not. So federally, the use of marijuana is still illegal. So that was kind of in a quick summary what the arbitrator focused on, I think, and ruled on. And that's what we as a city focused on in the presentation to the arbitrator. The fact that if you go through our labor management agreement, there are, I believe, 14 references in our Appendix E, and our Appendix E covers all of our random and mandatory drug testing to federal guidelines. So there were guidelines on, first off, and I kind of mentioned this, the testing facility has to be federally certified. There were, let me think of some of the other ones. They refer to the Department of Health and Human Services. They refer to FDA as far as some of the definitions that they have. So reference to federal regulations is all throughout this policy. There is no mention of any state regulation. So that's what I think they really, truly based it on. So in working through the arbitration and working with the solicitor's office to prepare for this, one of the things we looked at in the state of Ohio, medical marijuana, okay, is legal as long as you have a card. You can prescribe for a card online. Or I shouldn't, let me step back because I don't want to use the word prescribe or prescription here.
Recommended.
Okay. You can register for a card and get a card and go online. But in Ohio, what I have found out is that doctors cannot prescribe medical marijuana. It is a class still considered a Schedule E drug, and there is no way that they can prescribe it, write a prescription for it. What they can do is recommend it, and they can put it in a treatment program, but they cannot prescribe it. And there is no mention of that in our labor management agreement. It refers to prescription drugs and not to drugs that are recommended, if you want to say. And I will say on the union side, they tried to really argue that and fight that point, but I don't think it had any grounds whatsoever. Where in our contract it mentions about prescription drugs, it mentions about the FDA. It references that. So we use the FDA, the federal definition for prescription drugs. The union tried to argue that the arbitrator should basically take out a dictionary and open it up and use that definition as a prescription drug. And again, it didn't gain any ground or any weight. So they also argued the fact, what I thought was really interesting to try to say that it was an actual prescription, is the bottle that the medical marijuana was in and how it was exactly similar to and had all the same characteristics as a prescription drug. It had the name, it had a childproof cap, it had the medication, how many times to take. It was all on the same bottle, and they tried to use that to verify that it was a prescription drug. But again, I don't think they found any grounds with the arbitrator on that. We also have a special or a specific guideline that if we are to change our vendors for our drug testing facility, that it must be mutually agreed on by the city and by the union. And it says specifically for breathalyzer tests, and it does not mention urinalysis tests for drugs. So they were trying to argue that point because the city did actually change vendors, okay, but in the union was not in agreement with it and was not asked about this change in vendor. But again, it had no real grounds because they were tested through a urinalysis test and not the breathalyzer test for these. So let me see what else. Those were probably the biggest things that were were brought up. One of the things also in Ohio, I believe the OVI law for for marijuana is 35 nanograms per milliliter. Our contract reads anything over 50. So we argued the point that, it's a liability for members on this department to be allowed to use medical marijuana, because any one of our members could be put behind a wheel at any time to drive one of our medic units, or if they're qualified to drive, one of the apparatus. And they tried to brought up the point that was invalid because the 35, the OVI law number, is actually lower than what we test for. It was an interesting point, but again, I don't think it got any type of grounds for them. They were arguing a lot about how the members did not show any signs of being intoxicated, and they brought people in to testify to that as witnesses that, they've never noticed them being intoxicated. And they tried to weigh heavily on the fact that, even though they were over the limits that were tested, they were not intoxicated while on duty. And I think that's a real tough one to argue because, the one person had almost 7 times the limit that we test for in his system. And I guess he's been using it for a longer period of time because your body, I guess, will, I don't know if I want to say store it or build up a tolerance to it, that if you've used it for an extended period of time, it's not uncommon that you'll have higher levels versus someone who is just beginning to use it. They were requesting to get all their time off restored and also get reimbursed for their $350 for the class that they were required to take. That was, if you want to say, their compensation, and none of that. Basically the arbitrator ruled in the favor of the city, and none of that got approved. So I think that's pretty much where we are with it. We're still looking at the disciplinary piece of it. Matter of fact, one of the cases is going to a hearing officer today, and he will decide the actual discipline that's going to be that the member's going to receive for testing positive. Both these members, it was the first time they tested positive. They've been good firefighters, but we basically followed the union contract. And like I said, it was a contract interpretation, and the arbitrator ended up ruling in favor of the city. So that's it in a nutshell. And I'm sure if there's any other questions on it at the end, we'll probably start more conversation.
Great, thank you, Chief. All right, Chief Moore, you're up next to discuss your arbitration. You're still muted.
That's me, Jack. I was jumping in without unmuting my mic. So our arbitration was a little bit different because it involved CBD oil. But go back to the beginning. For the city of Whitehall, we have two reasons that we can test. One of them is for reasonable suspicion, which we have a reasonable suspicion checklist. And the other one is post-accident testing. So what we had was a member that got injured in a training accident. And anytime we consider that to be a post-accident, as even a vehicle accident would be. So when he went to the hospital, they did post-accident testing for drug and alcohol. So our member came back showing positive for THC. And when they sent the test for verification, they confirmed that. So in the city of Whitehall, on our drug-free workplace policy, it states that anytime a person tests positive for an illegal substance or one of the banned substances, they will be put on given a second chance agreement. So you'll be asked to complete a series of tests over the next year and training and meet with counselors, doctors, etc. But you'll be able to retain your job. For this particular member, since in the previous 12 months he'd had a DUI and received a suspension for, the city HR kind of took over and asked for termination for this gentleman based on a violation of our rules, which one of our rules is a violation of laws, rules, policies, or procedures. So they took that as a second hit to the progressive discipline, and Human Resources and the Safety Director wanted to terminate this person. As I previously told Jack, one of the things that happened internally was I kind of disagreed. The way I felt like we should follow our drug-free workplace policy, since it was clearly listed the first time you have a post-accident testing. That's what we do. So the gentleman was terminated, employee was terminated, and subsequently filed a grievance to get his job back. So when this did go to arbitration, one of the things the union tried to prove was that this was CBD oil and not smoking marijuana, naturally. So there was a lot of testing that went on, and independent labs tested whatever substance he was using or said he was using. And that was one of the arguments, that the THC in his drug test came from the CBD oil. He had been using CBD oil for migraines at the time. So when this went to arbitration, a couple things happened. The union felt like he should have got the second chance agreement under the drug-free workplace policy. And they also tried to show that this was not an illegal substance that he was using because it was CBD oil. When in the arbitration, the union was asking for, they wanted the gentleman to be reinstated with all back pay and benefits. At the time of the arbitration, he'd been off about 6 months. The union, in their side of the arbitration, they wished that he remain terminated. So when the decision came back from the arbitrator, I would say he kind of split the baby. What he did was give the employee the job back, but he did not reinstate pay and benefits. So the employee did come back to work, but there was, by the time the arbitration decision come down, he'd been off work almost 8 months. So he did not get his back pay reinstated. But as we talked about in the webinar last week, it did show that apparently CBD oil, enough use, can cause you a positive hit on your post-accident testing. So I think that's all I got, Jack. I hope that wasn't too fast.
Nope, that was fine. And anybody that's got any questions for Chief Moore, we'll hold those. And next, Chief McCann.
Thanks, Jack. I think I unmuted. Am I okay there? We're a pretty small department compared to the previous two chiefs, obviously. And when we had our incident, just some points I want to bring up. We were not under a collective bargaining agreement at that time. We do not do randoms, only just post-accident and reasonable suspicion. We are now under collective bargaining, but really we didn't address it much in the first contract. Our situation was we had a firefighter who was part-time and was part-time for almost 2 years, got his medic card, and we hired him as a full-timer. So that puts him under our policies back under probation as a 1-year probationary firefighter. And when he started that year, we noticed some performance issues where he was coming in late quite a few times. And we were working through that too, but he did get to the point where we had to suspend him. Then one day he was late coming to work because he had sideswiped a guardrail with his car and was driving through our town, which we're a small community, with parts hanging off his car, to where the police pulled him over and said, "Hey, do you know what's going on?" And he kind of acted funny there. Hindsight, they should have asked him to get out of the car, but they didn't. So he comes to work. They let him drive back to work, which was only, he was about a quarter mile away. So then a few more weeks go by, and 3 firefighters came into my office and said, "Hey, I think we have a firefighter that is on drugs." So we have the usual checklist from BWC, and we have some from our legal side. So they did that, and I did the same thing. And I said, "Hey, I think he really is." Some of the things he was doing on duty that day is he took his personal gear, all his turnout and helmet and all that, and he put part of it by the engine. He put a part of it by the medic, because we cross-manned vehicles, and some of his equipment he just set on a shelf. And he was frustrated of why people would do that to him. Then during that event as well, they were trying to change out oxygen. They noticed he wouldn't release, for almost a half hour, he did not release a oxygen wrench from his hand. So we took him up for reasonable suspicion, checked all our boxes. When our doctor called me, she had a couple problems. She said, one, it's positive for marijuana. He was using, he admitted to me at that time, nothing. I asked him prior to going in, you on anything? Will this come back right? And he said, yeah, this is not going to be a problem. So when she called me, she said, no, he did test for positive for our marijuana, but she said it's not very high. She said, my concern is all the other medications he's on with CBD oil makes him unfit for a safety sensitive position. So I contacted the firefighter, and she would not allow him to come back to work until she met with his doctor to find out if these prescriptions and what he's doing. So amongst with those conversations, his doctor refused to write a letter that said he recommended that he use this CBD oil to help with his pain, and that would never have recommended it with the medications he was on. So what we did internally, because he was under probation and refused, that he did not tell us that he was on the other medications, he held true that he was allowed to take CBD oil and come to work like that. We met with our attorneys, and we went ahead and terminated the employee under our probationary. He had too many tardies and conduct on becoming a Central Ohio Joint Fire District firefighter. He never contested it. We've never heard from him again, and that's where it's at right now. Mine's a little shorter. We never went further with it past the certified letters.
Okay, great. Thanks, Mark. All right, and then we'll get to Chief Dan Stitzel. Dan?
Thank you. So we've been working on this for a few years now, and I was over in Riverside before I came to Franklin. We had a couple incidents there, and one was a full-time union covered by the agreement, and then another was a part-time. So we tested for post-accident, random, and reasonable suspicion. So the first one was a post-accident. It was one of our new employees, young gentleman, very inexperienced. He was driving one of our medic units in a very tight, confined space neighborhood, and he ended up rubbing the medic unit down the side of another vehicle, and did a fair amount of damage. And obviously, it was a parked vehicle, so he was at fault. And due to it being his at fault and the amount of damage, per policy, we had to get him tested. So we went in, got him tested. He came back positive for THC. It's very surprising to everybody. We talked to the crews before the crash. Or his behavior before the crash. They did not suspect anything after the crash, did not suspect anything throughout the investigation. We reviewed the police body camera. He didn't show any suspicions of impairment or anything like that. We brought him in for his hearing, spoke with him. He immediately confessed to using CBD oil for some injuries that he had. And he actually brought in the oil to show us what he was using. And it did say THC free on the label. He thought he was safe. He didn't think there was any issues with that. And we kind of had to have some conversations with the city administration and the HR director. So back when we all first started doing this research, Jack asked me to help with this firefighter and the marijuana project. And one of the people that I reached out to was Kurt Verone, and he was talking about we really need to rely heavily on the impairment part of this when we're looking at these firefighters. So that's what we kind of did with this one. We really focused in on that, and he really didn't show anything. We didn't see anything that caused that before or after. He was able to come back to work. He wasn't able to drive until we were able to get the results back. But we just watched him, and nobody ever saw anything going on with him that caused us any concerns that he was actually using marijuana or anything that illicit that would cause us any concerns, other than he was using something that he thought was THC free that wasn't. The other one was a random testing. And again, very similar situation where he had a knee injury, and he came back positive. He was very shocked. He actually had the bottle with him at work that day. He went back, got it, brought it right out to him. He said, "This is what I'm using." Again, right there on the label, THC free. We again took him to City Hall, had a meeting. This one was part-time, so we didn't have to do the hearings and all that. So we went right into the HR director, sat down with him, kind of had the same conversation again. What we did with both of these is very similar. Everybody agreed that doing a last chance agreement, basically explaining that we're going, in lieu of discipline, you're just going to agree that you're not going to use CBD oil, medical marijuana, or you're going to agree to additional tests for over the next year, because we need to kind of protect ourselves to make sure that we're not being lied to, or that you're not using this as an excuse. And that's how we kind of protected ourselves. But we also wanted to make sure that we were confirming that these individuals weren't using, that if they were, we were going to be able to get them the help that they needed also. We did follow up with some unannounced testing. We called it random, but it really wasn't. We just walked in and said, "Hey, you're going to go get tests today." Since they agreed to it, the union with the full-time person, they also agreed that they were fine with that. They cooperated very well. So we kind of looked at that as a success story out of both these individuals. They both completed the year without any further issues in the testing. They both came back clean. They're both really good employees. I think we learned a lot through those situations, where we end up having additional training citywide. We told all the employees about CBD oil, how they're not FDA regulated, how they can say THC free, but they contain THC. If it's not certified, if it's not tested by a lab, they probably should not be using it. And especially our service department with their CDL licenses, and how that could have consequences beyond what the city can control. So we had that conversation with them. And we walked out of that whole situation thinking that we learned a lot through that whole process, and we were able to make them a little bit safer, a little bit more knowledgeable. So we feel that, you know, we don't think we have anybody in there using CBD oil anymore, knowing that the risks are involved. I think that they were just using them. They saw THC free and thought, yeah, we're fine here. There's no issues. So I think the education component that came out of this is what really helped us out in those situations. So we kind of looked at those are success stories. We really didn't have to get into arbitrations. We didn't get into terminations or anything like that. We were able to work those out internally. So that's all I have.
Great, thanks, Dan. Before we open it up to questions from the audience, Annette, we got to our two attorneys, and I let either Kevin or Kelly, if they found anything striking in any of the four descriptions that the chiefs had, that they would want to comment on before we go to questions.
Well, I'll go first. I think the last situation was a very positive outcome, no pun intended, as far as both of the firefighters, the way you were able to handle it internally. And obviously you had a situation there where, and this came out in the Whitehall arbitration that I read, is that, you know, a positive test is a positive test. And the fact that CBD oil had labels, at least in our last situation, where it says THC free, you know, folks just didn't realize, and they're using it, and there was no indication of impairment in the performance of their duties. Well, what do you do to them? I mean, in the Whitehall case, because there was a positive test, the firefighter was found to be in violation of the policy. In this situation, though, I think they took a fairly open-minded approach so that they saved 2 careers, as opposed to automatically going down a different route because of the fact that they were using CBD oil. That's just my initial reaction.
Yes, thank you all for sharing all of those. I've seen some of the same issues in the cases that I've been involved in too, and just looking forward at what is coming. I mean, the rules are going to evolve on this topic, like even the prescription recommendation issue. I think if the FDA reschedules from, or if the Department of Justice agrees to the Department of Human Services request to reschedule it from a Schedule 1 to a Schedule 3, then THC is going to require federally a prescription. So that's going to have a trickle effect down on states like Ohio to see whether we would follow the federal rule on that. Looked like it was pretty likely to happen about a month ago, but now I think the federal government's a little bit busy with other things, so I'm not sure if the Department of Justice will get to that yet. But you know, the difference between CBD, THC free, I agree with what Kevin said, and you know what you all have gone through, is that the labels don't necessarily tell the story about what's inside, unless I think it was the city of Cincinnati that actually had the metric label on it, probably, or an MJ Freeway label, that you could trace it back to certificate of analysis and third-party testing. And that was on the marijuana, but some CBD companies that are licensed will have that same type of tracing mechanism, so you can trace it back to the actual certificate of analysis. And you know what I'm seeing here is that if you want a zero tolerance policy, it's clear that you can have one, and that the arbitrators are upholding that as of right now. For those of you who have gone to arbitration, it looks good. But I'm also hearing that there's some benefit to using CBD, that you have some firefighters out there who, you know, as opposed to using opioids. And so if there's, you know, how do we craft policies that, you know, can maybe permit that certain level, and how do you make sure it's safe? And I think that's where we're all at, you know, trying to figure those testing rules and what is impairment and things like that. But yeah, so thank you all for your presentations. Those were great.
May I chime in real quick, Jack?
Go ahead.
Something that Kelly brought up as well, that one thing that I found interesting in the Cincinnati situation was where the arbitrator had concluded that with respect to the change in the testing facility, how they were not required to notify the union because the provision in question specifically said mutual agreement as it related to breath testing, but not as to urine testing. The arbitrator made that distinction and concluded that. And one of the things that the arbitrator said is that where you have the most controversy is over breath testing as opposed to urine testing. And I just want to point out to you that in another world in which I travel, which is as a prosecutor, prosecuting OVI cases, I did find that very interesting because I will tell you that in the defense of OVI cases, I routinely have dealt with the argument that urine tests are far more unreliable, if you will, as opposed to breath alcohol content test. There's been all kinds of, particularly as it relates to obviously to determining alcohol, but most of the tests that we get challenged as far as motions to suppress, you usually always get them with urine test as opposed to BAC tests. So I thought that was interesting. That I understand the reason for the distinction, because the contract clearly said mutual agreement as it relates to breath testing. But I found it interesting that the arbitrator said, well, and this makes sense because breath tests are more controversial, and so that's why there would have to be a mutual agreement as far as a changing in facility. But I will tell you that in what I do as far as a prosecutor, that's not the case. But I did find that interesting.
Chief Breitfelder, you want to comment about that?
I'm sorry, did you throw that to Jack? I didn't hear.
It was the chief from Cincinnati, I believe. Is
Yeah, Chief Breitfelder.
No, I mean, I really don't have anything else to comment on that.
Yeah, sure.
What was interesting about this whole thing when we went to arbitration, I was going to be sitting in there as a representative for the city the entire time, but they immediately, the union objected to that because I do fall under a union contract with Local 48 representation. Okay. So I did not get to see any of their, what they presented during the arbitration, and was only brought in as a witness as a result of that. So, and it was just yesterday that I actually got a printout of what they presented, their summary, and got to review it. But
okay.
And Kevin, I would also agree with Kevin though that there has been a lot of challenges on the urine analysis, and the Department of Health and Human Services has put in place passed a rule, I think in June, that said they would allow oral testing for THC. Mm-hmm. So saliva, not necessarily breathalyzer, but saliva testing. Right. But that won't go into effect until they being the Department of Health and Human Services, approve 2 certified labs. Okay. And as of, I checked the other day, October, they have not approved any labs, but it's supposed to be more accurate in terms of recent use. Mm-hmm. That the saliva test are supposed to be able to tell use within 24 hours up to 7 days. Mm-hmm. Whereas the urine, we all know the problem with THC in urine is that it could be metabolite that was used weeks ago off duty. Right. Even in some cases months ago, they were big users. So testing is a big issue too.
Okay, let's open the floor up to questions from the audience. You raise your hand.
He is muted. Richard Vober is muted. There he goes.
Good morning, everybody. I appreciate everybody doing this call. A lot of this stuff, we're dealing with some issues right now, so I find a lot of it very intriguing. Question for Kelly and or Kevin regarding levels. If somebody tests positive on a drug screen at 81 nanograms per milliliter and states that they were using a particular CBD product that doesn't have any of it's got some Delta 8 in it, but not Delta 9 according to the label, which I know is always questionable. Is that a possibility in your mind, or is that a definite no-go?
I mean, I'll just jump in first, Kelly. I think it's a no-go based upon what in reading the Whitehall decision, on the pure basis that because under federal law, marijuana is still a Schedule 1 substance. And what I got from that whole case was a positive test is a positive test. And while they did, I think, in the long run, recognize that this was a situation where it wasn't an impairment. I mean, it was the test was conducted because he was doing bailout drills and, had wrenched his arm pretty good. And there was nothing to cause them to think in any shape, fashion, or form that he was impaired. But what you get out of this is it doesn't matter. Once you choose to use CBD oil as some sort of treatment, you run the risk of this because it's not regulated. You don't really know what you're getting in the oil itself until it's possibly too late. So I wouldn't, if I had a client, and if I might, we had a situation here in one of the jurisdictions that I represented where we had a great employee that was actually an aquatics manager, and he had horrific arthritis issues. And he came to us though and told us from the start, hey, I've had no relief with any type of treatment other than using medical marijuana. And I know that we have a drug-free workplace policy, but I really need to be able to use this. And we told him, you can't, you can't use the CBD oil. You can't, anything that, could cause you to have a positive test. You're in a very highly, a safety position, being in charge of lifeguards and conducting, CPR testing and life-saving testing, all that. So he ended up resigning his position because he was not going to go off of something that had provided him with relief. And so that's kind of a very tough situation. But Chief, in your situation, as you relayed, I think that from the Whitehall arbitration, I think you run the risk. I think a positive test is a positive test, and I would steer away from it. But that's my thoughts. I don't know what Kelly thinks.
Yeah, no, I think you agree with, or that's true with what the arbitrators would rule. But I look at this one from a different angle. The question, as you posed it, was he was using Delta 8. And so this is where we get into a really murky area of cannabis and how you write your policy, because you've got clear THC is typically Delta 9 THC. That's the chemical compound, and the structure is how many bonds it has. And that is Delta 9 is the psychoactive component in the cannabis. What they've come out with now, this Delta 8, it's not CBD. It's from a hemp plant. So it's from a legal hemp plant, but what they're doing is they're taking a CBD molecule and chemically changing the structure of it to create this Delta 8. And Delta 8 mimics Delta 9. So when they take it to testing, most testing facilities cannot tell the difference between Delta 8 and Delta 9,
Right.
because their structures are chemically so similar, and actually their effect on our body is so similar. Delta 9 is the natural THC that, that's why some people get, an inconsistent high with Delta 9. Well, Delta 8 is basically synthetic, chemically structured hemp derivative that looks like Delta 9, and it's very it's unregulated, completely unregulated. And I want to say unsafe. I mean, that's kind of maybe too broad of a word, is unsafe, but it's unstable. So in some cases, a Delta 8 can be very potent, and maybe you guys as first responders see this more than I'm aware of, is when you respond to on EMS runs, Delta 8's very unpredictable. One gummy It doesn't work the same as CBD, and it doesn't work the same as Delta 9 because it's a hybrid. So I would consider Delta 8, even though it's legal because it's unregulated. It wouldn't be considered the illegal Delta 9, but it has the same or worse effects than what THC does. And it's not CBD. It does come from a hemp plant, but it's not CBD. I think CBD in a is non-psychoactive, even though it might have a little bit of THC in it. So you might get some levels. 81 is kind of borderline. I will tell you that that's 81 is probably what it is the test that was run can't tell the difference between Delta 8 and Delta 9. So the 81, and I know Delta 8 can be intoxicating. So I would be concerned about that. If you had a CBD test or a THC test and the person claimed they were using CBD, but your numbers were in the teens, if we're talking more like 18 instead of 81, that I think is very indicative of somebody who is using a full spectrum CBD. And when you combine THC and CBD together, if you have more CBD than you do THC, the CBD is going to counteract that psycho effect. So even if somebody is using a full spectrum CBD, like a honey stick in their coffee or something that has that trace amount, they might over time build up to a 17, 18, or maybe even a 20 on the test results. There's if it's used with CBD, there's very little chance they've had any psychoactive effect. And so then we look at why are we prohibiting the substance? What's the purpose of it? The purpose is for safety so that they don't drive under the influence or, show up on a scene unable to function, and use the judgment and everything that you want. So that's a great question, Chief Bober. That would be a unique situation, although it's not that unique. I mean, I've had myself cases where employees buy the Delta 8 at the gas station, they vape it, not realizing that it really is mimicking Delta 9, and it's not healthy.
So Kelly, would you still believe though that because it's so difficult to discern which is Delta 8 and that the arbitrator would still they're not going to get into, I wouldn't think, expert testimony as to I think they're going to, when they ultimately conclude we have a positive test.
Yeah, I agree with you, Ken. I think the arbitrators, if the city is arguing in favor of a termination or discipline on a zero tolerance policy, so far what we've seen is most arbitrators, especially in your line of work, are upholding those zero tolerance policies. I think going forward, what we need to think about is making sure our policies are tight enough with the future changes on prescriptions and such. And then there's that issue of if you want to allow it, if there are places that want to allow CBD, but not, obviously not on duty recreational marijuana, that the test is not foolproof to tell you what it is they're using. And there are certain labs that can test down to the nanograms of Delta 8, Delta 9, CBD, CBG, CBV. They're just not approved by the Department of Health and Human Services yet. So it's getting your union to agree on a lab that doesn't have that stamp of approval from SAMHSA or NIDA, or somewhere.
Are there any other questions?
If nobody's stepping forward, I do have another question relating the test. So I just read a new contract from Texas, Austin, Texas, and in their contract, they now allow the oral testing, two swabs, saliva test. If with all these changes that are going on, I think it would be prudent for the fire service to consider a different type of testing. So in your legal opinions, Kevin and Kelly, the oral testing versus blood testing, we've heard what you have, your thoughts on the urine testing, but is either one of those a better alternative for particular samples?
I mean, blood and hair are gonna be more like urine. It's gonna carry that residual amount because THC is like it's stored in our fat cells. That's why it hangs around longer than water soluble drugs. So most of our other drugs on those lists that we're testing for are all water soluble, and so 24 to 72 hours they're flushed out of your system. THC, CBD, those cannabinoids store in your fat cells, which is why they hang around, those metabolites. So blood, urine, hair, all gonna catch old test. Saliva seems like it would be a good the better answer, and the Department of Health and Human Services, I think, is agreeable to that. But like Kevin said, from the prosecutor's side, that they're not 100% reliable either. And if you've done breathalyzers, you see how they're challenged by
Yeah.
defense attorneys. It's going to be the same thing the unions are going to challenge. And up to prior to these cases here that we were looking at, there's a long line of case law and arbitration decisions that require you, if you want to rely on a test result as a presumptive evidence of impairment or violation of a policy, you almost have to bring the lab people in to certify their test. There have been many cases that have been lost by employers by relying on a test result, and the unions were able to say it's not that you need to have somebody here to authenticate that test. So there are only 14 labs in the country that are certified by the Department of Health and Human Services to do these tests for, like, Department of Transportation. And we use those rules and regs from the DOT. This came up in my arbitration, that firefighters aren't required to have a CDL. They're not covered under the DOT, Department of Transportation rules. The reason we use their rules is because they've been tried and tested and found to meet the constitutional issues that we, as government officials, are bound with our employees to follow the Fourth Amendment rights to be free from unreasonable searches and seizures. So we default to those, but even the defaulting to those 14 labs doesn't necessarily mean that when you go to a hearing, you have a certified test. We might need to bring.
You got to
Yeah.
get them to show up too, Kelly, right? I mean,
Yeah, you got to fly them in from Minnesota to
Right.
testify.
And sometimes that's just not going to happen. You're going to
So
try to reach a resolution.
I'd say the best solution there is in your union contracts, for those of you that have union contracts, policies, if you don't, is to put a self-authenticating clause in there that if it's a Department of Health and Human Services certified lab, the results are self-authenticating.
That's
Good
point.
Yeah. And if you're using a non-certified lab, if you can, like the Cincinnati language has mutual agreement with the unions,
Yeah.
tell them that we're doing this for their benefit. We want to let them, if you choose to do this, use products which are less harmful than opioids, but that might not cause intoxicating effects. But you need to have a lab that can distinguish between THC, Delta 8, and CBD. And if you can get them to agree to the lab and that their results will be self-authenticating, there's a lab up in Kalamazoo, Michigan that can do that, and they use oral fluids. And just by the way, for those of you who are familiar with the cutoff levels, I see the chat, there's curiosity on cutoff levels. For an oral saliva testing of THC, the cutoff level is 4 nanograms. So it's very low when you're going to that type of test to see in recency. So while they're giving the benefit of having the oral test, which is going to have a shorter measuring time, it's very low cutoff. So that could be why they're having trouble certifying a lab. But yeah, there is one in Kalamazoo, Michigan. It's called Fluid. Let's see. Okay. I'll put it in the chat. But again, that would be, best bet would be to get it something like that agreed to with the union and use that type of lab to be fairly certain and reliable of what they're ingesting, what they're using, what the effect is.
Thank you. You're muted, Jack.
I asked for any other questions, and it doesn't appear that we're going to get any other questions. So we've got about 5 minutes left. So is there any closing comments from any of the panel?
So the one other thing that came up was drug interactions, and I forget whose case that was. Maybe Chief McCann talked about the interactions of THC, CBD, and other drugs. I do believe that the FDA or one of the federal agencies just came out with a proposal or a statement that they're going to start including drug interactions with THC on certain medications. So that there are several sites, if you type in drug interaction, where you can pull up if you have blood pressure medicine, cholesterol, what people are on, to see if there is an interaction with THC, because there certainly can be interactions with your prescription medications and THC. Certainly there's an interaction with alcohol and THC too. That's not a desired outcome for most people. So
And Kelly, I don't think that's coming until we federally regulate it. I think these guys are selling it on the internet and they're there for the quick buck. And, it's hurting the fire service and probably more than that, but today's conversation is fire service. You don't see the federal government regulating, allowing that, or when we approve it at the federal level, the use of CBD.
well, it's federally legal. CBD is.
Sorry, yes.
There's
Marijuana.
yes. Do I see it becoming federally legal? I mean, there's the recommendation from Department of Health and Human Services to reschedule it to a Schedule 3, which would require a prescription. It'd be like ketamine and some of those. There's also a push with some senators, half a dozen or so U.S. senators that have written a letter to the Department of Justice saying that they would be in favor of having it descheduled altogether. So the Department of Justice is, it's an arm of the executive branch. The president has given them his feelings. The Department of Health and Human Services has at least acknowledged that there are medical benefits, which is why they've recommended rescheduling from a 1 to a 3. But I don't know if they're going to take it completely off the schedule altogether, but there are positions that are supporting that. So we'll see.
Thanks.
I just want to say that for us, education really became key. There was a lot of it's legal here, it's illegal there. So, getting these young firefighters to understand, that just because you can doesn't mean you should. Just trying to get them to understand that, yeah, it may be legal in the state of Ohio, but that doesn't mean that you're allowed to use it. It doesn't mean that you're allowed to use it while you're on duty. It doesn't, just trying to get them to understand what they are and are not allowed to do. You make it black and white as much as possible for them, because they didn't understand, and they thought that they were okay. They just believed the label. They didn't realize that FDA didn't regulate it. They didn't understand any of that kind of stuff. So education really became a huge part of our success story. And that's a big part of all of this, I think.
Yeah, I was going to say, I think an important message from, the chiefs and the administration is that they make it clear to the firefighters that, if they're using any of those products, that if they're injured and they get tested, that there's the high likely ability that the Bureau of Workers' Comp will deny their claim.
Yeah.
And then it'll be interesting to see what happens, when they try to take it to their benefits insurance, and the benefits insurance says, oh no, wait a minute, this happened on duty.
Right.
And it would be pretty cyclical for them in trying to get their injury taken care of.
Yeah.
Agreed.
Yeah, good point.
All right, I guess we're good. We're down to 1 minute. I want to thank all 6 of our panelists in that, and everybody that joined. this is recorded, so you can share it. It'll be on the members' website, Nat, that if any of the other chiefs that you talk to that are interested in what the panel discussed today, it'll be available on our website under the member section. So thanks again. Thanks, Kevin, Kelly, Chief Brightwater, Brightfelder, Chief Moore, Chief McCann, Chief Stencil. Everybody have a good day.
Thank you.
Thanks, Chief.
Yeah.
Sure.